21J337, right, Matt?
Yes.
Okay.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning.
Good morning, Your Honor.
Good morning, Your Honor.
Good morning. And so this is the matter of 21J337, Mr. Duran versus Antonio Rivera. And I believe Mr. Rivera is challenging the $900 use and occupancy figure that was imposed upon him by the court. Is that correct?
Yes, that is correct, Your Honor.
Okay, Attorney Body, I'll hear you.
Thank you. May it please the court. My name is Miriam Bhatti, and I am representing the petitioner, Mr. Rivera, here today. Mr. Rivera filed this petition to request review of a housing court order, which ordered him to pay his landlord $900 a month as a condition of maintaining an appeal of the trial decision in his eviction case. We are requesting that.
Let me ask you this question. The $900 figure that was set by Judge Horan, correct? And was that done in a margin endorsement?
I don't follow, Your Honor. I apologize.
When she issued her order, did she write it on the side of the motion itself?
Yes, Your Honor.
Okay, and in that order, she said that she was ordering $900 use and occupancy as was set by Judge Kelleher and Judge Winnick. Is that correct?
That's what she said, Your Honor, yes, but that was not the use and occupancy set by Judge Kelleher or Judge Winnick. Right,
they said it at $450. Is that fair to say?
Yes, Your Honor.
All right, I'll hear you.
So, Your Honor, Chapter 239 of the Massachusetts General Laws establishes the procedure for setting these monthly payments, and Section 5 specifically of that statute gives Mr. Rivera the right to seek review of the housing court's order. This is a de novo review, and in these appeals, Your Honor is not evaluating the court's order for an abuse of discretion. The housing court's order should be set aside because the judge applied the wrong standard when determining the fair payment. The case law is clear that the court should weigh a number of factors when determining the proper payment. These factors include not just the fair market value of the unit, but also the respective financial positions of both parties. The housing court—
You rely on Davis v. Comerford? Is that the case you rely on for that?
Yes, Your Honor. Davis v. Comerford and New York Bank Mellon v. King.
Mellon v. King, though, that wasn't a landlord-tenant case, was it?
No, Your Honor. That was that was a foreclosure case.
Okay.
So it's our understanding that the court erred by ruling that the only factor at issue was the fair market rent value, and that Mr. Rivera's indigency was not relevant. The judge also stated that she did not believe that she had the power to look at the financial conditions of the parties, and also failed to conduct an evidentiary hearing, which was requested by Mr. Rivera. Would you like a brief recitation of the facts, Your Honor?
I think I'm familiar with the facts.
All right. At trial, the housing court ruled against Mr. Rivera on his legal defenses and counterclaims.
Let me just say this. Suffice it to say, Mr. Rivera lived in the apartment for 16 years. He was paying $400 a month. The building got sold. The new owner wanted to increase the rent. And essentially, that's what brings us here today. Mr. Rivera challenges the increase in rent based on habitability of the apartment and some other conditions within the apartment. That's what the trial was in front of Judge Kelleher, correct?
Correct, Your Honor.
Okay, go ahead.
As you earlier mentioned, that in a pre-trial order and in the trial decision, two other housing court judges ruled that the current fair market value was $900, but based which was based on testimony and other affidavits. But notwithstanding these facts, they still ordered Mr. Rivera to pay $450, and that's what they found fair. Here, unlike King, here Judge Horan ordered him to pay $900, but she did not take into consideration any of the other factors that Judge Winnick had used in making that determination of setting the use and occupancy at $450. Mr. Rivera is indigent and he cannot afford the current use and occupancy at $900. And if he is unable, no, Your Honor. No, Your Honor. His sole source, he is very disabled. He's 66 years old, and his sole source of income is Social Security disability benefits. His income is $901 after the deductions. So if he is asked to pay you $900 for the use and occupancy, he will have nothing left to maintain other of his life's necessities. And if he is unable to pay this amount, he will lose his right to appeal.
So the payment was ordered to be paid until September, is that right?
August, Your Honor.
August.
Yes. So as we are asking you today for a de novo review to consider all legally required King and Comerford factors and use all the evidence in the record to set the use and occupancy at $400, which was his rent for the past 16 plus years. We also request that the decision be made today because the petitioner cannot afford to pay the $900 for the month of August. And if he does fail to pay that amount, his appeal will get dismissed. And he should not lose the appeal due to the failure to pay the amount that he can in no way afford.
What do you say to the figure of $450 that was set by both Judge Winnick and the trial judge?
Your Honor, that figure, Mr. Rivera was ordered by the court. He paid, however, this past month that he paid the $450, he wasn't able to pay his utility bills and his phone bill because of that extra $50 going towards rent. He can pay it, but it's still going to be a hardship on him to pay the extra $50.
Anything additionally, Attorney Bhatti?
No, Your Honor.
Thank you very much. Attorney O'Neill, your floor.
Yes, thank you very much, Your Honor. And again, for the record, Your Honor, Attorney Craig O'Neill on behalf of Gustavo Duran, trustee. Your Honor, this has a somewhat protracted history, as the court has seen. There's a fairly involved hearing by Judge Winnick with respect to the use and occupancy. I believe in Judge Winnick's decision, he anticipated that the $450 rent as a fair rent during the pendency of the trial. He sort of makes a reference in a footnote that the $450 number is going to be, in all likelihood, somewhat short-lived. He recognized that the fair market value of the property is $900 and the landlord's ultimate right to seek a rent of that value.
Do you agree with Attorney Bhatti that Judge Horan's order, which said $900, based on the finding of Judge Winnick and Judge Kelleher, was not exactly what they had ordered? Do you understand that question? I apologize.
I think I understand the question. And I think what Judge Horan actually said was that the fair market rent of the property was $900. I think asked, why during the pendency of this appeal it shouldn't be $900. And I think they tried to argue that that wasn't the fair market value of the property. I could be wrong with respect to that, but I think Judge Horan's reply was the fair market rental value of the property is $900, which had been determined first by Judge Winnick, and then secondly confirmed by Judge Kelleher. I think that's where she really went with the $900 figure.
Okay.
With respect to the hearing and the trial, Judge Kelleher did it was a fairly involved trial, as you can see from my memo. The defendant testified along with I think it was his sister as a witness. But most importantly, the City of Worcester code inspector who had been to the property testified and offered an impartial and unbiased insight into the condition of the property. And I think that helped Judge Kelleher with respect to, the credibility of everybody. And I think that's reflected in the judge's decision, that he made.
Do you agree that my review is de novo? Your paper seemed to suggest that I was reviewing for abuse of discretion.
Well, I agree that yours is de novo. What my argument with respect to the abuse of discretion was more with respect to an appeal of Judge Kelleher's decision. And the reason why I include that, because I'm not really quite sure what they're appealing. They're seeming to suggest that Judge Kelleher's findings, which were, I think, primarily gauged by the testimony of the City of Worcester code inspector, and then evaluating from there the credibility of the parties, would seem to suggest that that he made errors of fact and abused his discretion with respect to the facts. And I'm just pointing, and maybe it just wasn't clear in my argument, that really that would seem to be what the appeal is about. I don't think the appeal is a question that the judge misapplied, misinterpreted, or misconstrued the law. The appeal would seem to be that they don't agree with his findings of the facts.
That's not what I heard today.
Well, I'm talking with respect to the appeal.
Okay, we're talking about two different things. You're talking about the appeal of the trial versus the appeal of the use and occupancy figure.
Right. And what and that's why what I'm suggesting in that this appeal is somewhat without merit, in the sense that if they're really just appealing his discretion, I think that that's a fairly tough burden. And meanwhile, Mr. Duran is incurring yet a further delay with respect to the fair market value of the property. And the court, I think, has the discretion to weigh that as a factor as well. The Comerford versus Davis anticipated that that it would be a sort of a short-term situation where the person was required to pay use and occupancy, and that shouldn't have an impact with respect to presenting the case to trial, so that neither party would be prejudiced. I'm suggesting that now that trial has happened, it's a different time frame, it's a different cost, and that the court should look at what the actual fair market value of the property is. And I think the decision in Mellon Bank versus King, although it's a summary process action based upon a foreclosure, it recognizes and seems to look at that the issue of what Mr. Rivera, can afford should not necessarily be the sole factor and the guiding factor. And I think
it's one of the factors. You agree it's one of the factors.
It's one of the factors that the court can look at and apply some weight to. But I'm suggesting that in this situation where it's not a question of what the facts are going to be. In this case, the facts, at least initially, have been determined by the court. Whereas in Comerford versus Davis, they're talking about we don't know what the facts are necessarily going to be at trial, and so we don't want to prejudice either party. Now we're in a situation where a court has actually determined what the facts are. So to, in essence, require Mr. Duran to subsidize Mr. Rivera's unit, where somebody has made a determination as to what those facts are, just would not be a fair and reasonable shift of the economic burden.
In King, didn't they, correct me if I'm wrong, didn't they order less than fair market value? Wasn't fair market value $5,000? They ordered $4,000?
That's correct. I think, honestly, Your Honor, I think that's all I have, unless the court has questions.
I have no additional questions. Thank you both. I think I understand the issue. I'll take the matter under advisement.
Thank you very
Your
much,
Honor.
Your Honor.
Thank you.
Have a nice day.